welcome to Legal Insights with Shila Issue. Continuing our conversation on estate planning, we've looked at the traditional methods of planning an estate, and remember, we're talking about giving the power to a person to control what happens to his assets in his absence or in the event of his incapacity. We've looked at the traditional approaches, and then today I'm just going to be discussing a more modern approach, which is the trust, creating a trust. For some of us, we may have heard about it one way or the other, but the trust is a tool, it's also a legal tool that is used to manage the assets of a person, either whilst in his lifetime or after his death. And it's a tool that has quite a lot of advantage over the traditional method. And so, unlike a will that you still need to go to the court to enforce in the event of the demise of the testator, a trust does not require recourse to the court. The trustee has powers to simply execute the content and the agreement of the trust deed. Again, unlike the will, which is subject to a probate fee, the trust is void of any tax liability attached to it. So that gives the testator or the estate owner, in real terms, a better advantage when you make use of a trust. Okay, so I'm sure you will ask, what is a trust? A trust in itself is a tool or a situation where owner of a property appoints another person, whether individual or corporate body, as the case may be, to manage his assets for the benefit of a third party. So the trustee is appointed by the settlor, someone called the settlor, the owner of the property or the owner of the asset appoints a trustee who then becomes the owner of the assets and then manages the assets on behalf of certain beneficiaries. So you see that the trust is like a tripartite arrangement where someone owns the property, hands it over to another person to manage on behalf of another person. So you see that it's a tool that can be used to manage assets even while a person is alive. So someone can decide to say, I want to set up a trust for the maintenance of my wife and my children. I want to set up a trust for the education of my children. Whether I'm alive or in event of my demise, the education continues. I want to set up a trust for the maintenance of my dependents and extended family. And that way, what it means is that the assets is managed profitably on your behalf by the trustee for the benefit of these people. So what's the critical thing we need to look at then? What's the capacity of a trustee? Who can be a trustee? As I mentioned earlier, a trustee can be an individual, in which case there will be really nothing particularly stringent, except that there needs to be the creation of a trust deed. Trust deed is the legal document that appoints the individual as now the manager of that asset on behalf of certain named beneficiaries in the trust deed. It can also be a corporate body. As a matter of fact, there are so many corporate bodies that are offering such services today in Nigeria and beyond. So the settlor in this time appoints this corporate body and gives it the power to operate on his or her behalf. And that, of course, is also done through the execution of a trust deed. And the trust deed contains the details of what the estate owner wants to be done with his assets and then how it will be distributed. So the function of the trustee will be one that he has to manage the assets. He has to. So don't forget that in this case, the settlor, once he's appointed, is no longer in the picture. The asset now belongs to the trustee. Then the trustee exercises full ownership rights, however, on behalf of someone else. So he manages the assets. He has a duty to invest So a trustee has a duty to invest either the fund. Remember that the subject matter that is held by the trustee can be any form of asset. It can be fund, it can be real property, it can be stocks, it can be bonds, it can be intangible assets that is held on behalf of the settler. So the company then has a duty to invest it, to manage it, to administer it. So if it's a real estate, the company has a duty to ensure that the real estate is put to profitable use, and then the benefits, the profit is then distributed and according to the desire of the estate owner. I think it's also critical to mention here that the property owner must have a capacity to appoint a trustee. It then means that it cannot be an infant. Critically, you must be an adult before you can set up a trust. And again, the person must have mental capacity. You must have adequate mental capacity. That means there must be no incident of any form of mental illness or anything that goes to the root of the mental capacity of the settler. So once that is established, then it can effectively set up a trust. And when it does that, remember it is done through the instruments of the trust deed, which must be signed and executed by the property owner. It's also important for me to mention that a trustee has certain duties. When a trustee has been appointed, there are certain duties that the trustee has, one of which is that first and foremost, the trustee has a duty to manage the assets. That is the very reason why he's been appointed, oftentimes because of their professional capacity and competence. So when a trustee is appointed, he has a duty to manage the assets, whether real or intangible assets. And then again, the trustee has a duty to invest. So remember, we talked about the fact that it can be funds, the subject matter, the assets that the trustee is managing can be funds. So he has a duty to invest it. So what it means is that what you give to your trustee is not exactly all that it distributes to the beneficiaries. He must have invested it and multiplied the assets. Again, he has a duty to distribute. It's just remember that a trust is a tripartite arrangement. You are setting up a trust for the benefit of other people. So he has a duty to distribute according to what you have stated in the deed, trust deed. And then finally, the trustee has a duty to render accounts. It's important that the render account, of course, it can be quarterly, monthly, annually, whatever is agreed in the trust deed, but you must render account to say this is what we have done, we've managed, we've invested, we've earned this 20% after this, and then we've distributed in this manner. That account is critical to the duty of a trust. I think with this, we've been able to look at the concept of trust albeit in a very small, little perspective. It would also be wise to speak with your lawyer, even if you're making use of a corporate body. It's wise to engage the services of a legal practitioner before you go into setting up a trust. But critically, remember that the trust gives the benefit of being able to have someone, especially when you engage corporate bodies, they can do it professionally, handle the management of that asset, whether investment, funds, stock, then they can manage it and administer it in such a way that it must be profitable. So it's not just what you are putting in as the assets that remains there. They are expected to multiply to manage it properly as part of their duties as a trustee. So I hope with these few episodes on estate planning, you've been able to gain quite a lot of legal insights, and then you'll be able to make the appropriate decisions for yourself. Remember, estate planning puts away a whole lot of stress and enables you to control what happens to your asset, enables you to perpetuate your wealth, enables you to ensure there's peace and tranquility in your home or in your family after your demise, and most of all, also gives you capacity to control the taxes that your assets will be subject to, whether when within your lifetime or afterwards. Thank you very much.